Hi, my name is Brian Venton with another My Town Media opinion piece that I've called Is Age-Restricted Legislation Unconstitutional? The Online Safety Amendment Social Media Minimum Age Bill was passed late on the last sitting day of our 2024 political calendar. It was subsequently lauded by global mainstream media as being a good thing. But is the legislation unconstitutional, and does it breach fundamental freedoms inherent in our Australian Constitution? Now, while some changes to the law were made, Cam Wilson, the editor of Crikey, made a very valid observation. He said, while it's true Australians won't have to put in their government ID, this law all but guarantees that more Australians will be forced to either provide government ID or have their face scanned if they want to stay online. Something, he says, many Australians will object to. In other words, to access the news via social media or otherwise use social media, all Australians, young or old, will still be forced in some way to prove who they are to a social media entity. The supplementary explanation material, point 9, says, for clarity, this means that government-issued identification or the use of an accredited service cannot be the only method for users to assure their age with age-restricted social media platforms, but may still be one available option for them to use. Now let that sink in. The tentacles of intrusion still lurk deeply in the background here. And whilst the government has addressed some aspects of concern, the constitutional breach, in my view, goes far deeper. Now, why is that? Because it has to do with the forced restriction or the intentional attempt by legislation to drive a control mechanism that deprives a person's ability to freely access news, information, opinion, or otherwise engage in a two-way social media communication process unless they are aged verified. Now that appears, in my mind, to be a serious breach of our Constitution. Now, as I see it, the government doesn't have the authority to deny or limit by any means a constitutionally implied right of people to engage in public discourse across any platform, irrespective of age. The Victorian government Solicitor Office, in a blog titled The Implied Constitutional Freedom of Political Communication, discusses at length this broader question of freedom of speech. And they say, it's not uncommon to hear people in Australia talk about their right to freedom of speech. However, many people are surprised to learn that the Australian Constitution contains no such right. Rather, our Constitution provides for an implied freedom of communication about government and political matters. The implied freedom isn't an individual right. It restricts laws which interfere with free communication about government and politics. They go on to discuss three questions that must be answered when deciding whether a law infringes implied freedom. And this is really interesting. First, they say, does the law effectively burden the freedom in its terms, operation, or its practical effect? Call it the burden question. Second, if so, are the purpose of the law and the means adopted to achieve that purpose legitimate in the sense that they are compatible with the maintenance of the constitutionally prescribed system of representative government? That is the legitimate end question. And third, if the answer to the second question is yes, is the law reasonably appropriate and adapted to advance that legitimate object? The reasonably appropriate and adapted question. Now, this question of proportionality is discussed at length in their article. So let's consider these questions briefly and how they might apply to this new legislation. In terms of the first question, does this new law have a burdensome component on the community that impinges on the implied right to an individual's freedom? I suspect under any measure, this legislation does impose a burden on people by restricting their access to information streams. It seems a legislative measure has been put in place to limit an implied constitutional freedom. In terms of the second question about legitimate end, it largely depends on what side of the fence you sit on. The government obviously believes the legislation has legitimacy, and there are all sorts of suggested rationale to justify that position. But it's also becoming increasingly obvious that mainstream media and other stakeholders have vested interests in a yes vote position too, perhaps because social media has become the go-to for news and is impacting their bottom line. But from the public's perspective, once they consider the implications, I imagine they will strongly argue for a no position, largely because it impinges on their ability to engage in the free flow of information and communication. Any action to restrict access to social media should, in my view, be seen as a deprivation of liberty and an attempt to control the flow of information to and from that source. And to give the public just 24 hours to make submissions on this bill was a clear giveaway that the government was only interested in promoting a yes position. So the third question is about proportionality and whether the legislation is reasonably proportionate to the intended outcome. I would say no, because the legislation appears to be excessive and controlling and ignores existing protocols that could be effectively used to obtain the same or similar outcomes. So the idea of burden, legitimate end, and reasonable proportionality are all very important questions that need to be answered in respect to this legislation. Now, in their article, the Victorian Government Solicitor Office suggests if the first question is answered yes, and the second and the third question is answered no, the law will be invalid. Now that's interesting. Time will tell whether that same conclusion can be applied to this new legislation. So, is there a case for a High Court challenge to this legislation? Well, I would suggest there might be, but it will take sharper minds than mine to argue that possibility. What are your thoughts? Feel free to comment. And I'll put some links up in the comments for further reading. It should be noted that the Victorian Government Solicitor's Office has not, as far as I know, considered the constitutionality of this legislation. And the comments in this video are an expression of my own honest opinions. Now, thanks for watching, and remember, the things that appear are not always as they seem. Bye, and see you next time.